Thank you. Please be seated. Good morning. This is the time set for oral argument in Billy Brumett et al. Versus MGA Home Healthcare, LLC, our case number CA CV150047. With us today is Mark Moran, presiding judge of the Coconino County Superior Court. Mark, thank you for serving as a judge pro tem today. Each side is allocated 20 minutes for oral argument. Appellant, if you wish to preserve some of that time for rebuttal, you're free to do so, but you will need to do that. We will not. Please use the podium clock for that. Out of respect for counsel, I would ask that those in attendance make sure your cell phones are turned off so that our discussion is not interrupted. We have read the briefs. We're familiar with the record. We've conferenced the case this morning. We'd encourage you to keep that in mind as you present oral argument. Also, please understand that arguments are being recorded today. They're posted to our website and then will be posted to YouTube. So when you take the podium, if you would, please tell us your name and the party you represent. With that, Mr. Meyer, you may proceed.
Thank you, Your Honor. My name is Kevin Meyer from the firm of Groening, Oberg, Woods & Wilson on behalf of MGA Home Healthcare. The trial court presided over a long trial. A jury returned a verdict in favor of the defendants, and then the trial court received a motion for new trial that was pending for a long period of time. And ultimately, the trial court reversed and granted a new trial. We're here today to ask this court to reverse that ruling and to reinstate the jury's verdict. Let me begin by first talking about the idea of the grant of a new trial and the discretion that's supposed to be paid to that. There are many cases that talk about the importance of giving the trial judge deference, having sat through the trial, having had a chance to observe the things that can't be observed from the cold, dead record. When you talk about the idea of a improper style of argument, perhaps a vouching or a golden rule argument, and you're trying to assess as an appellate court what the effect of that was. In that case, we really want to rely on the trial court because the trial court was with the jury and he saw the witnesses' testimony and he really has a sense of what impact that would have had. In this case, the issue is whether defendants violated a motion in limine. And our initial premise is that we did not violate the motion in limine. So before we reach the question of what effect any such arguments and testimony would have had, we wouldn't even reach that point because we argue that we did not violate the motion in limine.
Can I jump ahead, Mr. Meyer?
Certainly.
I know I'm taking you off track, but let's jump to motion in limine number 18. And I want to make sure I understand one procedural and factual issue before we talk about that. Judge Talamonte, I believe, issued a minute entry saying, I'm going to read the following statement of the case to the jury panel. Please let me know if you object. And as I recall in the record, the only objection was filed by MGA because you wanted him to add some language. Was there any objection to that statement of the case by the plaintiffs?
No.
Okay, thank you. All right.
It actually probably leads very well to where I was headed next. There was a statement of the case that was read to the jury in this case that the parties hashed out. I mean, to think that this issue was not something that was, foremost in the minds of both the court and the litigants is simply to ignore the record. This was heavily disputed throughout the case. It was a very closely watched issue. And ultimately, the trial court agreed to read a statement of the case to the jury that acknowledged that someone messed with the tube. And it didn't specify whom, and it certainly did not blame the plaintiffs, more specifically the plaintiff's husband. And in fact, the defendants were restricted from making that connection. However, it was clear from the court, from the evidence being presented, that there was a basis to say that plaintiff's husband was familiar with the tube and knew how to either adjust it or, the court talks about a continuum of verbs at a certain point here, whether it was reinsert, replace, and obviously those have distinctions that we'll talk about in more detail. But the point is, there was a reinsertion of a tube that had been established in the evidence and that was presented at trial.
Can I also interrupt you and ask?
No, thank you.
I know there was an objection during the opening statement, and Judge Talamonte ruled that the defense opening was consistent with his ruling in the statement of the case. Was there ever another objection during trial prior to the motion for new trial that MGA was violating motion in limine ruling number 18?
There is some discussion in which there's a clarification asked for ahead of time as to whether.
Well, about the Foley catheter discussion.
Well, I was thinking of another time when the question was whether it was going to be said that plaintiff himself had adjusted the tube, and there's a clarification that that's not going to happen, and I think that counts as an objection, and so in that instance, that would be the other instance I would refer you to. I think on the second day.
Okay.
Yeah. So that's what we have. We have a situation in which, the motion in limine were supplemented. There were several stops along the way during testimony. There was time to object during closing. There would have been time for curative instructions had they been offered. There were many instances in which this could have been raised during trial. Unfortunately, this really doesn't get resolved until after trial in the motion for new trial. And at that time, the suggestion is made that we violated the motion in limine. But when you read the argument for the motion for new trial, what you're seeing is that they're arguing that we made the affirmative representation, that MGA made the affirmative representation that her husband had actually reinserted the tube. And that's simply not true at all with respect to the record. That never occurred. When you look at Judge Talamonte's ruling on the motion for new trial, he says he's convinced by the reply. And that's very much the tenor of the initial section of the reply, is that we somehow have crossed the line and we have affirmatively stated, not just that we insinuated, but that we affirmatively stated that he reinserted the tube. And on that basis, the court said that a new trial was needed. And again, when it's something more ephemeral in the record that you can't see for yourselves, deference is required. But when it is patently obvious and specific as to specific testimony that was supposed to be offered, that's something this court can review and can review for an abuse of discretion. And if this court finds the record lacking, this court can reverse the trial court's ruling on that point. A second point I'd like to quickly address is sort of the secondary argument that Judge Talamonte addressed and cited as a basis for a new trial, which was the idea that this motion in limine number 12 should have been granted. And if you look at that, motion in limine number 12 comes to this idea that there was insufficient disclosure and insufficient foundation from plaintiff witnesses regarding whether the tube could harden on its own. And if you look at the portion of the transcript that we cited, which is Appendix V to the opening brief, Judge Talamonte goes through and there's a heavy discussion in there, as well as in the argument on the motion for new trial, as to why the witnesses were not properly disclosed as to that topic. So there again, even if the Judge Talamonte thought on review that there was a sufficient basis, this court can review to determine that there really wasn't a sufficient basis, either in disclosure or foundation. What you had is witnesses, doctors and nurses who were not disclosed as having had experience with these types of devices, who could say, who later on said, "Oh, well, yeah, I know what that is, and I can tell you based on my experience that hardens." So
let me ask you this: setting aside Dr. Schuster, as I read the record, and it's a huge record, so I might have missed something. The only witness at trial that the plaintiffs attempted to question along those lines was Nurse Greenberg, and Judge Talamonte sustained a disclosure objection that we don't have a transcript of the bench conference. Is that correct?
That is correct.
But you're saying that the lack of disclosure was discussed again during the oral argument on the motion for new trial?
Yes, exactly. And again, it's not very, that's just not a record that's very well developed. And so because the trial court has provided two different bases, that there is a sufficient record for this court to review, and it doesn't rely on things that this court couldn't review from the cold dead record. We believe that this court has the discretion and the authority to reverse the grant of summary judge or the grant of new trial in this case. This is a case that was heard by a jury, and the jury took a long time and considered it properly, and we're asking for the court to reinstate the jury's verdict.
What are we to make of the grounds that the Superior Court did not rely on in granting a new trial?
I think those are fairly well discussed in the opening section of the motion for new trial argument. I think there's a pretty cursory review in which Judge Talamonte eliminates those arguments pretty quickly with respect to, for example, Nurse Bosman's records and the dispute between help me and stop you hurting me. I think those are resolved fairly quickly. I don't think those are really properly before the court. I think that if this court wanted to get a real determination of that, it should remand for Judge Talamonte's consideration of those issues.
Well, we can affirm if the court was correct for any reason, even if we disagree with its stated reason. And just from my perspective, the only one of those additional grounds that he didn't rely on that I might like your input on is the one that's been characterized sort of as the help me statement. He ruled during trial that the door had been open. Talk to me about that.
There's a lot of detail to that one. There was a dispute as to what was said and the conditions, who was present at the time, what other reasons might have been in the people's minds as for not going into the room when that was happening at the time. But I think ultimately, that issue just doesn't really get to an issue of prejudice at that point. I think everything is preserved in the record, and anything that they would have wanted to argue from the help me eventually came out anyway, so I don't see how that would be prejudicial. They really haven't made a strong prejudice argument on any of their additional arguments. Unless the court has additional questions right now, I'll try to reserve my remainder.
Thank you, counsel. Mr. Gregory.
Good morning. Robert Gregory, Your Honors, appearing on behalf of plaintiffs Billy Brumett and Angela Brumett. I want to start with the first of the two issues that defendants have appealed on, and that concerns the evolution of terminology that occurred throughout the case. But I really want to back up 5 years. The confusion that consisted with those terms didn't begin during trial. It began 5 years earlier. In fact, the day after Nurse Bosman provided care for Connie Brumett, in which the injury was alleged to have occurred. On that date, November 23, 2009, Susan Bosman kept medical records, nursing records for that night's care. And in the morning, she turned the care over to Connie's husband, Billy Brumett, the plaintiff in this case, indicating to him it was a good night for Susan, no problems, and her nursing record, importantly, was void and silent as to the issue of what happened with the feeding tube. No statement at all about that. Very soon after that, in fact, I believe it was the next day, Susan Bosman met with her supervisor. This was necessary because of the fact that Connie Brumett was now hospitalized and questions arose. In her consultation with her supervisor, Susan Bosman indicated, I did nothing with the feeding tube, denied touching it, consistent with what she had put in the nursing record. Then the terminology starts to creep in. Once discovery began in the case, plaintiffs propounded requests for admissions, and in response thereto, Susan Bosman, for the first time in the case, acknowledged that she had advanced the feeding tube. And then let me back up just a little bit, because prior to the discovery beginning, in her answer for the first time in the case, we hear Susan Bosman saying, I changed the feeding tube. So we've gone so far from being silent and not having anything to do with the feeding tube, to change the feeding tube in her answer, to advance the feeding tube in her discovery response. moving forward into the joint pretrial statement just a couple weeks before trial, this was a hotly contested issue, and in the minute entry ruling on this very discussion of the meaning of this terminology, changed, replaced, inserted, or advanced, Judge Talamonte indicated someone, but not the plaintiff, replaced the feeding tube, and made a very clear point that this was not something to be discussed at trial. In fact, the judge reiterated this during the second day of trial. Your Honor asked the question about was there any further discussion about this motion in limine, and we're talking...
But before you go there, I'm not sure I agree with something you just said, because the statement of the case that Judge Talamonte read to the jury, apparently without objection pretrial by your clients, was defendants assert that someone removed the soft pliable tube surgically inserted on July 27, 2009 and replaced it with a hard, sharp-tipped tube that was removed during the surgery on November 25th. So that issue was in play pretrial.
Yes, but the point that I was making, and I think we're speaking about a different minute entry. This is a minute entry dated February 26th, in which Judge Talamonte said someone, and then he said parenthetically, not plaintiff, replaced the feeding tube, and granted plaintiff's motion in limine in that respect, that the defendants could not argue that Billy Brumett advanced or replaced the feeding tube. And I want to take the court to, and this is in page 35 of our opening brief, wherein there is a discussion during the second day of trial. This is off record, but we have the recording of that, where Mr. Broning for defense and the court is effectively arguing about whether or not this theory can be discussed in the trial. And on page 35, and I'm not going to read the entire transcript, but Mr. Broning makes the statement, somebody, and the court says, I know I've asked several times, and then Mr. Broning continues, somebody changed out this tube. There's no allegation that we did it. But then the court conclusively states, but you said you're not claiming that. So what we have here is a mid-trial reaffirmation of what had already been decided in the ruling on the motion in limine.
Well, the way I read that in context is Judge Talamonte saying to Mr. Broning, who was urging him to reconsider his ruling on number 18 with the Foley catheter incident, and Judge Talamonte was saying no, to do that would be a 180-degree reversal of what I said before. He reaffirmed his pretrial ruling, but at no point did he backtrack from the statement of the case he himself had read to the jurors, saying that it was defendant's position that someone had replaced it. It seems like it was consistently stated that someone could be argued. It just couldn't be argued that it was either of the Brumetts.
Yes, and I think that's where the confusion crept into the case, Your Honor, is...
Confusion. I mean, it doesn't seem confusing.
Well, we have this, and defense counsel referred to this semantics of the terminology, and we spent quite a bit of time at trial trying to educate the jury, and really the judge and ourselves for that matter, because these theories are newly developing during trial. I want to make the note that at no time, up until the time of trial, had defendants ever alleged in any of their disclosure statements that they were going to posit the theory that Mr. Brumett had advanced, reinserted, replaced, or done anything to the feeding tube. It's simply not there. And so I understand the court's initial ruling on motion limine number 18, and I understand that the court gave some latitude to defense to discuss Mr. Brumett. Yet part of our complaint is the fact that this is a new theory that arrives on the eve of trial that we spent effectively 2 weeks talking about. And the rules of civil procedure and evidence require that if this was a theory that defense was going to pursue, then that should have been disclosed during the year and a half that we had during discovery.
And just to be clear, the theory was that either of the Brumetts had replaced the J-tube with the one that was removed, because we know from pretrial proceedings in the statement of the case that the defendants had taken the position that someone did it.
That's correct. And yet, because this was such a hotly contested issue during the motion in limine and subsequent briefing that occurred on that motion, plaintiff's position was this matter should not go before the jury in any form. It had not been disclosed. None of the disclosure statements, none of the discovery responses, none of the answer submitted, none of that advanced the theory that Billy Brumett had done this. In fact, I think Judge
But tell me
Talamanti, I'm sorry.
where it was said in any context that Mr. Brumett did it. Because you said that in the motion for new trial, and then when they sort of challenged you in the response, the only thing that you quoted was this from the defendant's closing argument, and this is the statement by defense counsel. Whoever reinserted the J-tube, if it was reinserted, or whoever changed it, if it was a different tube, had knowledge that that had been done, but not Nurse Bozeman, she couldn't have known. That's what you cited as the violation of the motion in limine. I'm having a hard time seeing how that's a violation.
Okay. It's a valid question, and it brings us full circle to the evolution of the terminology in the case. If you'll recall, in the answer submitted 3 years earlier, defendants for the first time agreed that Nurse Bozeman had changed the feeding tube. It's the first time we get that terminology. Now we're in closing argument, and for the first time, Mr. Broning is telling the jury she did not change the feeding tube. So contradicting the answer upon which plaintiffs had relied for the entirety of the case and telling the jury something that simply wasn't true. Either we accept the answer for what it was, or the answer is a misstatement. But we had relied on that throughout the entire discovery in this case.
But how does that violate the ruling on number 18? It doesn't say that Mr. Brumett did it. I understand your argument that it might have been problematic in other respects, but that's not why Judge Talamanti granted a new trial. He found that defendants violated his ruling, and so I'm trying real hard to see where in the record that violation of that ruling occurred.
I'll answer a semantic question somewhat semantically, and I apologize for that. I think what happened is during trial, and I realize that we don't have the benefit of disclosing a voluminous record, but there was obfuscation, I think is a fair word, of interchanging of the words replaced, reinserted. Even in the closing argument that you just cited, Your Honor, the terms of reinserted or replaced or changed are used in the same sentence. We believe that that's very confusing to the jury, especially because it's introducing terminology that the judge had already ruled was impermissible. Your Honor, if I may, I'd like to move on to some of the other issues. I want to address the issue that was raised about the hardening of the feeding tube. Just real quickly, defendant made the statement in their brief that the two retained experts and the treating physician were not qualified as experts under Rule 702 to opine about whether or not the feeding tube had hardened. I find that argument a little disingenuous because their own retained expert, Dr. Macho, was not a products liability expert, as defendants argued in their brief. He's a surgeon. So if he was qualified to opine about the hardening of the feeding tube and was no more than a retained expert, then there's no reason to deny plaintiff's experts and treating physician who had personally observed the hardening of the feeding tube to testify.
But, you know, I asked Mr. Meyer this question. I'll ask you the same question. I probably missed parts of the transcript, and only parts of the transcript were filed. But I did not see anywhere where plaintiffs attempted to question a witness other than Nurse Greenberg about the hardening of a J-tube at trial.
The reason for that, Your Honor, is there was discussion off record, and we don't have the transcript for that, in which Judge Talamanti said we're not allowed to proceed with that line of questioning. And that...
Well, we can't rely on things that aren't part of the record. So all we have is a record that shows that he denied motion in limine number 12, subject to proper foundation being laid, and then at trial, the record that we have only reflects a question to Nurse Greenberg that was objected to and sustained on nondisclosure grounds. So we really can't look at things that aren't part of the record.
Well, then let us look at what is part of the record. For example, Dr. Banerjee was the treating physician for Connie Brumett. had been treating her for some amount of time and made personal visits to her home and had treated her elsewhere, including when she was hospitalized. Dr. Banerjee and her assistant, who worked with her, made records that are in their own medical records, notations that the feeding tube had crystallized. That's the observation of a treating physician. Why we were not allowed to examine Dr. Banerjee about that alone mystifies.
Mr. Gregory, wasn't she specifically in her deposition asked that question, and she said she basically didn't want to speculate? She wasn't that familiar with the tube?
Thank you for that question, Your Honor. The scope of the context in which that question was asked at her deposition involved whether or not she had particular expertise, such as a products liability expert might have, in knowing when feeding tubes harden. She was honest in her answer. No, she doesn't have specific training in that, but for that matter, neither did defendant's expert. No one in the trial could say that they were specifically trained in analyzing the chemical properties of or physical properties of feeding tubes.
But I think the second part of Judge Moran's question gets to the deposition testimony by Dr. Banerjee that she didn't know what the crystallized reference that her assistant wrote down meant.
Okay. And that's recorded in the deposition, and yet the medical record, I think, speaks for itself, that the recording is made 4 months before the events of November 2009 in the records for Dr. Banerjee, that the observation was made by the assistant for Dr. Banerjee that the feeding tube had crystallized. Now, this contradicts the claim by defendants posited by their own expert, Dr. Macho, that he's never seen that happen. Well, Dr. Macho is not an expert either. He's a surgeon. And we advanced the discussion, which in our retained nurse expert did testify in her 40-plus years of work as a nurse that she had seen feeding tubes become hard or brittle. So we believe that the trial court got it right in granting a new trial on those grounds. Now, I want to move ahead to the 5 issues. Defendants suggest and plaintiffs agree that to the extent that this court is prepared to rule on the 5 other bases that plaintiffs ask for a new trial, then I'd like to discuss just real quickly 1 or 2 of those. One of them is the help me statement. Your Honor asked the question about was the door opened, and I'd like to refer the court to pages 38 and 39 of our opening brief, particularly page 39. This is in defendant's opening statement, in which Mr. Broning stated, "There will be testimony in addition that you will hear and is recorded in the notes that it was not uncommon for Mrs. Brumett to yell repeatedly over and over again various statements, 'Stop, you're hurting me.'" Your Honors, a very careful review was done of all the nursing records. By ruling on motions in limine, the defendants were required to redact anything in the records that referred to help me, because the court ruled that those occurred in the past and were not relevant to the issue in the case. But the statement by Mr. Broning suggesting that Mrs. Brumett yelled repeatedly, "Stop, you're hurting me," severely prejudiced plaintiffs. Because
the problem you have there, and it's true with some of your other issues that Judge Talamonte didn't rely on, is there was no objection. And I know you argue fundamental error and prejudice can warrant a new trial, but not making a timely objection where there can be a curative instruction or counsel can rephrase the statement, that's a pretty thin reed to rest a new trial on when you haven't objected.
Okay. Plaintiffs understand. It's always a calculated risk to object during opening statements.
Although you objected on other grounds.
Well, because there was a very blatant, we felt this was blatant too, and plaintiffs took the judge at his word. Let's move things along here. And so, yes, we did not object as to this.
You
to this.
you want me to tell you what I think your stronger argument is on that one, and it's what I was alluding to with Mr. Meyer, is the notion that the door had been opened during trial. I'm intuiting from the way I read the transcript that the judge believed that Mr. Brumett's testimony that he had reviewed the entire record, and if you think entire record means all of the nursing notes, there were a lot of references to help me. So I'm guessing, speculating, that's why he believed the door had been open, but talk to me about that from your perspective.
Well, our understanding on the court's ruling on this motion in limine, we're talking about motion in limine number 9, was that the help me statements were just not relevant. That the only statement that was going to come...
The door was opened, and I mean, he did say it could be revisited at trial.
He did. But obviously, you don't have any argument occurring during opening statements, so that's... there's no grounds on the opening statement for the door to be opened. We hadn't made any statement during our opening statement that would suggest that we were going to revisit issues that the court had said that we couldn't, nor did we want to. And we don't find anything in the record, and I don't believe anything's been cited, where this door was opened, allowing defendants to revisit what the court had clearly said they could not. And so we do believe that it was error. We do believe it was prejudicial for the court to allow this line of questioning to go forward when, in effect, we spent several days at trial ultimately discussing this very issue, the help me statements. And we believe it was extremely confusing to the jury. Now, my time is almost up, so I'm just going to real quickly say to you one last item that grounds for appealing for the new trial was Mrs. Brumett's, Mrs. Bosman's deposition. Ultimately, at trial, we were not allowed to bring any discussion about what happened at her deposition because she was later, almost a year or more later, determined to be incompetent.
But let me cut to the chase there. How could you be prejudiced by that? Because they filed a motion in limine basically saying, hey, there's no evidence that Nurse Bosman was impaired or had dementia when she cared for Ms. Brumett. It's irrelevant, and you didn't object. In fact, you said we have no objection to that motion. So how would that have made a difference to show this lady's deposition?
Well, to answer that question.
And I guess because it seems calculated to show the jury or to imply to the jury that this lady has dementia, and therefore she must have had dementia when she cared for Ms. Brumett.
I'm almost out of time. My answer, Your Honor.
Well, Judge Thumma might give you a few extra seconds. He's been known to do that.
I'll indulge you, counsel.
Thank you. I'll be brief. It's prejudicial in two, perhaps three ways. One is, and real quickly, at her deposition, Ms. Bosman really, and the court pointed this out, feigned an extreme lack of knowledge. We asked her what a nurse was. She didn't know what that was. Had you ever been a nurse? No. And went down a path of really extreme ignorance, perhaps putting on the appearance that she was already suffering from dementia. Yet, in the ensuing 6 months, Ms. Bosman participated fully in the litigation. She participated in disclosure statements, numerous disclosure statements, discovery documents, and negotiating a consent decree with the Arizona Board of Nursing in which her nursing license was revoked. And there's been an allegation that plaintiffs did not pursue this issue and they have to live with it. We disagree because the State Board of Nursing answered this issue for us. We didn't need to pursue it, in which the State Board of Nursing, ruling on the Brumett's complaint that they had filed with the board, said the circumstances described in the findings of fact of the consent decree and the investigation constitute unprofessional conduct pursuant to ARS 32-1601, being mentally incompetent or physically unsafe to a degree that is or might be harmful or dangerous to the health of a patient or the public. We had that ruling long before we ever went to trial, before Ms. Bosman was ever officially deemed incompetent. And we felt it was prejudicial that we were prohibited from discussing anything about that matter or about her deposition and her lack of knowledge, we'll say. And so we would also ask the court to consider not only affirming on the grounds that brought the case here, but on these other 5 grounds, and particularly the 2 that we've talked about. Thank you, Your Honor.
Thank you, counsel.
Thank you.
Mr. Meyer, rebuttal, and I'll indulge you with a minute or 2 extra if you need it.
Thank you, Your Honor. Judge Downey, in response to your question with respect to the help me statements, I just want to see if I can maybe clarify things a little bit better or improve upon my performance last time. With respect to opening the door, this is in page 28 of the opening brief. I think it really is what I think you were alluding to, which is the idea that there was an inconsistency in Billy's testimony regarding the review of the records.
Well, that was how I was viewing the open the door finding by Judge Talamonte.
Correct. And then I guess the question is, if nonetheless this court considers that to have been error possibly, I think the prejudice issue that I was alluding to earlier is on page 391 of the motion for new trial. And when I say page numbers, I'm reading the appendix. So it's actually page 15 of the motion for new trial argument. And in that case, Judge Talamonte is kind of speculating about what Angela's motives might have been, and why it might not have been a big problem. And actually, Mr. Gregory stands up and says, well, yeah, actually, we think we kind of explained that pretty well, that she thought she was in the care of someone who was trained and had to allow that to happen. And so it seems like they were conceding that there was no prejudice on that point. And unless the court has any further questions.
Thank you, counsel.
Thank you.
Counsel, thank you for your briefs. Thank you for your oral argument today. We appreciate them. You've given us much to think about. We will take this matter under advisement. We'll issue a written ruling in due course. Court stands adjourned.